Okay, Reformation of Contracts under Articles 1359 to 1369. Okay. So, Article 1359, class, okay, babasahin ko. When there having been a meeting of the minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement by reason of mistake, fraud, inequitable conduct, or accident, one of the parties may ask for the reformation of the instrument to the end that such true intention may be expressed. If mistake, fraud, inequitable conduct, or accident has prevented a meeting of the minds of the parties, the proper remedy is not reformation of the instrument but annulment of the contract. Class, tandaan ninyo, ang pwede lang na i-reform na contract ay yung mga valid contracts. Okay? What do we mean by valid? May mga essential requisites, okay, requirements, such as the consent, object, and cause of the contract. Kung meron yan, class, tapos upon writing the agreement, hindi na ilagay lahat or may vague or may ambiguous, etc. Or may mali, may mistake, di ba? Or sinadya ng isang party na hindi ilagay kung ano yung talagang nandun sa, ano yung napag-usapan nila, the other party may ask for the reformation of the contract. However, class, kapag yung mistake prevented the meeting of the minds of the parties, it is not subject to reformation. It is subject to annulment of contracts. Why? Because may mali doon sa consent, doon sa element na consent, di ba? So, or dahil nga hindi nagkaroon ng meeting of the minds because of that mistake, di ba? Therefore, hindi siya pwede sa reformation. Hindi mo siya pwedeng i-reform. Anong i-reform mo? Hindi nga siya valid contract. Di ba? It is a voidable contract kung mistake, fraud ang kanilang ang ground. So, pag-uaralan natin yun mamaya, ha? So, the effect of reformation is retroactive from the time of the execution of the original document. Next. Okay, reformation. It is a remedy by means of which a written instrument is amended or rectified so as to express or conform to the real agreement or intention of the parties. Okay? Ano ang reasons para i-reform ang isang kontrata? Mistake, fraud, inequitable conduct, or accident. Diba? And the instrument fails to express such agreement or intention. Diba? Kumbaga, kulang yung naisulat. Hindi kumpleto yung naisulat. Or may mali sa naisulat. Pero yung original agreement, yung mismo contract between the parties, valid in all aspects. Okay? So, ano rational ng reformation? Para at least mailabas yung totoong pinag-usapan, di ba? Di ba? Paano na? Kasi unfair naman na paano kapag yung isang party ang nag-prepare ng contract? O, nag-usap si parties A and B. Okay na yung kontrata nila. Ayos na ayos ang usapan. O, sabi ni B, A, ikaw ang magsulat ng kontrata. O, si A, nagsulat ng kontrata. May mga nilagay siyang hindi naman dapat nakalagay doon. Or may mali siyang interpretation. Ito yung naaalala ko eh. Ito yung sinulat niya. Pero mali pala yung naalala niya, hindi pala yon. Okay? Napirmahan ni B. Kasi nga tiwala siya kay A. Nung nabasa ni B, ay mali ito. B asked the court to for the reformation of contracts. Pwede ba yun o hindi? Pwede. Kasi unfair naman para kay B na i-enforce ang isang contract na hindi nagre-reflect ng kanilang pinag-usapan. Diba? So, it will be unjust for B para maging liable sa isang kontrata na hindi naman nagre-reflect ang kanilang pinag-usapan. Requisites of Reformation in general, ha? Again, there must be meeting of the minds of the parties to the contract. It must be a valid contract. The written instrument does not express the true agreement or intention of the parties. The failure to express the true intention is due to mistake, fraud, inequitable conduct, or accident. Class, yung mistake, kailangan mistake of fact. Okay? Hindi po pwede mistake of law. Inequitable conduct includes taking advantage by one party of the other party's illiteracy, abusing of confidence, concealing what is right should have concealing what of right should have been disclosed. Parang pangit yung pagkakaano nito. Drafting or having drafted an instrument contrary to the previous understanding of the parties and making the other party to believe the instrument other than it actually is. And fifth, in taking advantage of a mistake of the other party, known or suspected at the time of the execution of the contract. Okay, the facts upon which relief by way of reformation of the instrument is sought are put in issue by the pleading. So, procedural yan. And there is clear and convincing evidence, which is more than mere preponderance of evidence of the mistake, fraud, inequitable conduct, or accident. Meaning, evidentiary yan, class, ha? Kung sino ang nagsasabi na there's a need to reform the contract, of course, di ba? Siya yung dapat mag-provide the clear and convincing evidence. It is an elementary rule, class. So, ano pagkakaiba ng Reformation and annulment? Sa Reformation, there is a meeting of the minds of the parties. Yun lang, hindi na-express ng mabuti sa contract. Annulment, walang meeting of the minds. Diba? Kasi vitiated ng mistake, fraud, etc. Iba pa klaseng vices of consent. Reformation, it gives life to a contract. Diba? Si A and B, katulad ng example natin kanina, A and B, si A ang gumawa ng contract, medyo may hindi tama dun sa contract ng draft niya, napirma ni B. Si B asked for reformation. Ano ang mangyayari kapag ginunat ang reformation? It gives life to a contract upon certain conditions. Ano naman mangyayari kapag annulment? Yung mga magre-report sa voidable contracts, it completely nullifies a contract. Again, what's the difference of a void and a voidable contract? A void contract is void ab initio. Void from the very beginning. Annulment, it is valid until annulled. Article 1360, the principles of the general law and the reformation of instruments are hereby adopted insofar as they are not in conflict with the provisions of this code. Okay? So, in case of conflict between the provision of the civil code and the principles of the general law and reformation, the former prevails. The latter will only be supplementary. 1361, when a mutual mistake of the parties causes the failure of the instrument to disclose their real agreement, said instrument may be reformed. Ano ang requisites of reformation due to mutual mistake? First, the mistake must be of fact. Diba? Kapag it is a mistake of law, the remedy is annulment. Such mistake must be proved by clear and convincing evidence. The mistake must be mutual. Diba? Mutual mistake nga eh. Diba? Common to both parties to the instrument. And the mistake must cause the failure of the instrument to express their true intention. Class, babasahin nyo lang yan, maiintindihan nyo yan. 1362. If one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. Class, logic to, common sense. Of course, ang pwede lang mag-invoke ng reformation ay yung injured party. Bakit naman, di ba? Siya na nga may kasalanan, siya pa ang mag-i-invoke ng reformation. Kasalanan niya yun, di ba? If one party is mistaken and the other party has no notice of such mistake and acts in good faith, reformation cannot be availed of. Diba? 1363. When one party was mistaken, the other knew or believed that the instrument did not state their real agreement, but concealed that fact from the former, the instrument may be reformed. Diba? Again, yung injured party lang ang pwedeng man-invoke nito. Diba? Kasi yung concealment of the mistake by the other party is fraud. So, ayun lang. May ano yan, may tatandaan nyo, basta tatandaan nyo lang tong, tatandaan nyo lang na ang pwede lang mag-invoke lagi, wait. Okay. May sinasabi, he who comes to court should have clean hands. Diba? May Latin term yan tatandaan ko. Sige, tinatandaan ko kung anong niya. Kasi class, kapag ikaw ang gumawa ng mali, ikaw ang gumawa ng masama, and well, intentionally, mali yung ginagawa mo, alam mo, you have no right to ask the court for relief, di ba? So, laging sinasabi dyan, he who comes into equity must come with clean hands. That's the clean hands doctrine. Okay? Next. 1364. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument or of the clerk or typist, the instrument does not express the true intention of the parties, the courts may order that the instrument be reformed. Diba? In this case, neither party is responsible for the mistake. Diba? Either party may ask for reformation. Ang may kasalanan yan, yung nag-draft. Diba? Yun lang, napirmahan nila. If two parties agree upon the mortgage or pledge of real property or personal property, but the instrument states that the property is sold absolutely or with a right of repurchase, reformation of the instrument is proper. Okay? Bakit? So class, tandaan nyo yung equitable mortgage, ha? Yung mga ano yan. Bakit kailangan kasi class, kadalasan, 'di ba? Mapag-aralan niyo 'to sa sales, 'di ba? Mas madali class na for convenience. Pautangin kita. Si A, pautangin si B. Pautangin kita 1 million. A, pautangin si B ng 1 million. May collateral na, for example, house and lot. Hindi na bayaran ni B ang 1 million. Diba? Ang pinapirmahan ngayon okay, ulitin natin. Si A, pinautang si B ng 1 million. Hindi contract of loan ang kanilang with real estate mortgage, ang kanilang pinirmahan. Ang pinapirmahan ni AKB ay deed of sale. Bakit deed of sale? Kasi class, kapag deed of sale, ang palalabasin nila, mas madali. Kapag hindi na bayaran 1 million, akin na to, akin na yung lupa mo. Kapag class mortgage, kapag loan with mortgage, hindi po pwedeng i-appropriate ni nagpautang, ni oblige yung house and lot automatically. That is pactum commissorium. Pactum commissorium is void. Okay? So, kailangan itong dumaan sa mga public auction. Di ba? Ang problema, matagal yon. At baka may possibility na hindi sa kanya mapunta yung lupa. Kung gusto-gusto niya yung lupa. So, ang sabi niya ay, ang palalabasin natin ay pacto de retro. Sale with the right to repurchase. Kapag ganun class, at nalaman ng court, may evidence on that assumption, on that fact, di ba? Reformation is proper. Okay? Next. There shall be no reformation in the following cases. Simple donations inter vivos, wherein no condition is imposed. Diba? Wills. Bakit? Kasi personal yan eh. Kapag namatay na yung tao, walang pwedeng mag-reform. When the real agreement is void. This is common sense, class. Number 3. Diba? Anong i-reform mo? Void nga. Diba? Wala. It is inexistent. 1367, when one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. You are estopped. Diba? You are estopped to bring an action for reformation if you previously brought an action for its enforcement. Hindi po pwede yan laban o bawi yan, class, ha? So, you are estopped. Ayan. Papaliwanag lang natin yung cases where reformation is not allowed. Simple donations inter vivos. What is inter vivos? Within the lifetime. Diba? Wherein no condition is imposed. Okay? Wills. Ayan, sinabi na, strictly personal and free act which cannot be left to the discretion of a third person. So, kapag namatay siya, wala na, namatay yung testator, paano pa i-reform yun? Patay na siya. Class, kung nabanggit na yan before, strict ang rules sa wills. Ha? Bakit strict ang rules sa wills? Kasi class, kailangan i-make sure na yung intent ng testator, yun ang masusunod. Diba? So, kung may magulo dyan, at namatay na si testator, wala na tayong magagawa nun. Okay? Real agreement is void. Definitely, it would be useless. Diba? Kahit na i-reform mo na i-reform yan, kung agreement ay void, walang mangyayari. Where one party has brought an action to enforce the instrument, estoppel. Ha? Kasi, ikaw na yung ikaw na yung you are asking the court to enforce this contract. Tapos bigla mo sasabihin na, ay, hindi pala, i-reform natin yan, court. Kasi magulo, may hindi tama dyan sa kontrata na yan. Tatanungin ka na court, bakit nung una gusto mo siyang i-enforce kahit na magulo siya? Hindi na po pwede yun. Bawal. 1368. Reformation may be ordered at an instance of either party or his successors in interest if the mistake was mutual. Otherwise, upon petition of the injured party or his heirs and assigns. Okay? So, tatandaan nila, if the mistake is mutual, either of the parties. Relativity of contracts, their heirs or successors in interest in lieu of the party entitled. In all other cases, di ba? Injured party only. And, yung heirs niya, successors in interest, etc. 1369, ito, procedural to. The procedure for the reformation of instruments shall be governed by rules of court. That's it for the reformation of contracts.